Hello and welcome, ladies and gentlemen. My name is Samir Shah, and I'm an M&A partner in Khaitan's Corporate M&A Group. Welcome once again to the sixth edition of our M&A Academy program. As a part of the M&A Academy, we have been consistently providing foundational legal knowledge and understanding on M&A transactions, processes, and other related issues to corporate executives, in-house legal teams, and other M&A ecosystem participants, and all of it in a corporate style training environment. Our subject today is joint venture structures. In earlier webinars, we have discussed acquisition structures, both involving shares and assets, and spoken about diligence and risk mitigation. Today, on the other hand, we will discuss, in my view, the fundamental aspect of transactional work to facilitate good, continuous, and profitable business. Often enough, businesses either don't have the will or the experience or the capability to pursue a new business opportunity by themselves. This leads to a clear opportunity to partner with another business that has what you lack, and hence leads to the discussion around joint ventures. Most joint ventures don't follow the same standard vein, as the business priorities of different partners tend to follow different routes. As a result, there is a significant level of customization to each joint venture. Nonetheless, what we as transactional lawyers look to do are to use the same basic building blocks and cement those together with our knowledge and experience to create an edifice or a foundation on which parties' aspirations can really take off without any limitations. As always, we will have a presentation, and post the presentation, we will have a Q&A session with audience questions. Please continue to submit your questions using the webinar portal. In this case, we had also asked for questions and inputs from the audience through our mailers, and we have received an unusually high number of requests, and we have a dedicated slide catering to that. As always, we will respond offline over email to questions we cannot address today. We will also send the presentation, the summary notes, and the recording of this webinar to you afterwards, and the recording will also be uploaded on YouTube. To introduce our speaker today, I have with me my partner Sarthak Sareen. He is an M&A partner based out of our NCR office, although he works on projects nationally. With more than a decade of experience and having studied both in India as well as the Western world, he brings with him significant deal experience on transactional work and joint ventures. We circulated his profile over email to all the participants, and you may have seen that he has advised on multiple high-stakes transactions, including having advised the CK Birla Group on their joint venture with Peugeot. So without further ado, I now invite Sarthak to deliver his presentation. Over to you, Sarthak.
Thank you, Samir, and thank you all for taking the time to join today's webinar on joint venture structures. A joint venture or a JV is a highly fluid concept, and pulling off a successful JV needs a lot of work and planning. You need the right partners, have an achievable funding plan, vendable yet realistic synergies, but most importantly, there needs to be an effective structure that is in sync with the parties' game plan for the JV. The intent of today's presentation is to discuss at a high level the key features of a joint venture, common structures for forming a joint venture, various factors driving the structuring exercise, and the critical issues underlying each JV structure. To make this webinar more practice-oriented, we focus relatively more on a 50-50 JV format and its key issues, as it is the most prevalent structure for doing an equity JV worldwide. We'll wrap up the presentation with a recap of the key takeaways before opening the floor for a Q&A session. As Samir mentioned, the webinar portal has a Q&A function where you all can key in your questions. Next slide, please. So diving right into it, a joint venture can be described as a strategic alliance between two or more parties for producing synergies through pooling of complementary yet individual resources and capabilities of the parties to yield a mutually beneficial result, effectively a bigger piece of the pie. When compared to an equity business or an asset acquisition, the key distinguishing feature of the JV is the synergies. That is the real USP of this format and the reason why parties collaborate. Because it is otherwise challenging or uneconomical for either party to produce such synergies or results individually. Synergy, simply put, is the combined effect of the individual resources that the parties bring to the JV, which should be greater and commercially more valuable than the sum of their separate effects, so as to justify the strategic alliance. So whether it is to access a new geography, market, or technology, or diversifying into a new business vertical, a JV model can certainly help accelerate the achievement of such goals in an economical and a time-effective manner. There are many interesting examples at the global level to support this. We all know Sony Ericsson, a 50-50 JV between Sony Corp Japan and the Swedish telecom company Ericsson to develop and manufacture mobile phones and electronic devices. This JV lasted for a decade until Sony bought Ericsson out in 2011. Hulu, a media streaming venture originally founded as a JV in 2007 between News Corp and NBC Universal, is another great example. Hulu is now under the majority control of the Walt Disney Company. Another marquee example is United Launch Alliance, a 50-50 joint venture between two aerospace companies, Lockheed Martin and Boeing, which launched the Curiosity rover that landed on Mars in 2012. At the domestic level, while JVs in India are prevalent across sectors, historically they have been more common in sectors which are either heavy technology or capital intensive or require high technical skills. For instance, asset management. The key example here being Mahindra Manulife Investment Management Company, a JV between Mahindra and Manulife formed in 2020. Then telecom, a highly tech-reliant and capital-intensive sector where you have multiple JVs, including the most recent one being between Airtel and Hughes Communications for providing satellite broadband services in India. Infrastructure, again a capital-intensive sector where recently Tata Realty and Infrastructure and Canada Pension Plan Investment Board have formed a joint venture for developing commercial office space across India. While most of these features that you see on the screen are rather commercially oriented, from a legal perspective, the key feature that stands out is the JV agreement. The terms and construct of the JV arrangement are often and should ideally be documented by the parties in a definitive binding agreement. We'll discuss this aspect in further detail in the coming slides. Next slide, please. So moving on to the most common structures for implementing a joint venture, these can be categorized into two buckets: contractual JVs and equity JVs. An equity JV contemplates the formation of a separate legal entity for operating the joint venture. This is the most prevalent form for long-term broad-based joint ventures. Contractual JV, on the other hand, is more ideal for a short-term project where the creation of a separate legal entity is not feasible or necessary. Talking about the structuring consideration, there are several factors at play, both at a macro and a micro level, which ultimately drive the choice of the structure. Interestingly, at the micro level, the structuring is driven by the strategic and commercial objectives of the parties. And some leading questions that we often ask the potential JV partners are right there on the screen in front of you. These include, what is the purpose and the intended scope of the JV? Is the project long-term or short-term? For instance, where the objective is to set up an entirely new business activity for a long term, then an equity JV can be considered. Or alternatively, where the commercial intent is to grow, expand an existing business with the introduction of, say, a new technology, process, or brand, then a contractual JV may be a more efficient choice if the project is for a short term. Then, what are the immediate and long-term funding requirements of the project? And can these be met internally by the partners or require third-party financing? The key takeaway here being that third-party financing can be typically challenging in case of a contractual structure, as there's no separate legal entity representing the JV, so there are no allocated assets for collateral. And therefore, in this model, any financing needs need to be at the partner level. Then what is the degree of control that the parties want to exercise? If the preference is joint control, then equity-based model is recommended. However, if the parties intend to maintain exclusive control over their respective assets or IP, then they need to consider a contractual JV. Lastly, what is the risk appetite? A contractual JV runs the risk of being construed as a partnership and consequently can subject the JV partners to joint and several liability for the debts and losses of the JV activity. An equity JV, on the other hand, addresses this specific concern by adding a veil in the form of a distinct legal entity between the JV partners and the JV activity. Now, talking about just taking a quick detour before we talk about the macro factors. It's relevant to mention here that contractual JV is different from a partnership. Partnership is a more structured going concern and is legally recognized as a form of a business vehicle pursuant to the Indian Partnership Act of 1932. Similarly, unlike a contractual JV, a partnership firm has its own trade name and is required to maintain a separate book of accounts for the business. Now, coming to the macro factors. These are the factors that are outside the control of the JV partners. And these factors include regulatory restrictions and challenges. For instance, in case of a highly regulated sector, where say 100% foreign investment is restricted, such as insurance or defense, or where the foreign investment requires government approval, a contractual structure may be a better choice where the JV arrangement is for a limited purpose, such as licensing of technology or know-how for a product development. But if the project is long-term, broad-based, such as full service with life insurance business or defense manufacturing for a wide portfolio of products, then from our experience, an equity model is the default choice. Marquee examples in these sectors being ICICI Prudential Life Insurance, a joint venture in the insurance space, which is majority held by ICICI. In the defense space, the marquee example is Tata Boeing Aerospace JV, a great Make in India initiative to produce aerostructures for the AH-64 Apache. Then, what are the tax implications and sunk costs? Here, the key takeaway is that an equity JV obviously involves additional cost commitments for incorporating and running the separate legal entity. Lastly, what is the termination regime? For instance, winding up of an equity JV, given the separate legal entity, is onerous and time-consuming, and the process requires approval from the National Company Law Tribunal. This may not suit many JV partners where the duration and the scope of the JV does not justify such time and cost commitments. Interestingly, in our experience, often these macro factors end up overriding the micro factors when concretizing a JV structure. Next slide, please. So delving into contractual structures in further detail, this is the most basic form of strategic collaboration, and there is no corporate veil that separates the parties from the JV activity. Parties engage directly for a limited or a short-term project as independent contractors rather than shareholders in furtherance of a common purpose for profit. And the joint venture is structured purely through a contract. From our experience, such arrangements are highly functional constructs that allow JV partners to capitalize on new products, technology, or venture without being bound by the permanence of a separate corporate vehicle or incurring significant sunk costs. At the same time, this format also provides strategic opportunity to establish a de facto geographical presence, which can help increase market outreach for a foreign player or say to domestic players in a relatively time-effective manner. A well-known global example being Toyota's Suzuki Global Cooperation Alliance to establish and promote long-term cooperation in new fields, including electric vehicle technology and autonomous driving. Some of the specific activities where contractual JV format is commonly used includes project development in infrastructure industry, co-production projects in the media space, and principal-to-principal arrangements for distribution and marketing and manufacturing space. Talking about the governance aspects of contractual JVs, since there's no corporate vehicle to run and operate the JV activity, there's no supervisory board through which parties can exercise control. However, while in their respective capacity as independent contractors, each party retains the freedom and exclusive control over their respective responsibilities and deliverables for the JV project. A contractual JV should ideally be supported and supervised by a separate specialized committee consisting of representatives of both the parties, and the material decisions impacting the contractual JV, such as the profits, liability exposure, should be taken by the committee. Here again, the JV contract becomes the driving force, and an effective governance and operational regime needs to be negotiated and clearly documented so as to avoid any gaps or disputes in the future. Next slide, please. Now, talking about the pros and cons of this JV structure, starting with why this structure works. The chief advantage offered by this structure is flexibility and simplicity. This structure is simple and easy to implement with greater flexibility. Parties just need to focus on getting the underlying contract right, and there is no distraction for setting up and managing a new entity. Similarly, this model relatively offers unrestricted decision making. There's no obligation or statutory compliance around setting up a board at the JV level, as there's no separate legal entity. However, as we discussed, it's recommended to have a committee which can be more flexibly set up to take critical decisions regarding the JV. Again, since there's no separate JV entity, parties can utilize their respective assets and IP for achieving a common purpose without diluting their ownership interests. So ownership remains intact. Lastly, as we discussed, there's ease of termination. The parties can simply terminate the underlying contract, and there's no third-party regulatory body involved. Coming to the pitfalls, in the absence of a separate legal entity, this format often suffers from a lack of a clear structure and identity, which may affect both internal operations as well as the interface or contracting with third parties. Then we discussed the concerns around accessing external financing or the risk of potential uncapped liability exposure. Another risk that's noteworthy is the risk of potential tax exposure. A contractual JV can have significant tax issues if not structured properly, as the tax authorities may qualify such arrangements as an association of persons and consequently levy the maximum marginal rate, which could be as high as 40% if any member of the contractual JV is a non-resident. Given these issues, it's crucial that the terms of the JV should be documented in a definitive binding agreement, and the agreement should clearly identify and outline the respective roles and responsibilities of the parties, describe the profit sharing model, and consequences of breach. And lastly, most importantly, a robust risk allocation regime to address any third-party claims. Next slide, please. Now coming to an equity JV structure. As we've discussed, an equity JV is represented through a distinct legal entity, either a limited liability company or a limited liability partnership. The JV partners provide funding or other resources, which could be capital assets, technology, or IP, as their contribution to the JV entity. The key takeaway here being that unlike a contractual JV, in case of an equity JV structure, you have a separate legal entity which houses the JV activity. Coming to the formats of equity JV, there are two common ways to form an equity JV: greenfield venture and brownfield venture. In case of a greenfield venture, JV partners incorporate a new entity to house and operate the JV activity. An important consideration is, of course, the choice of the legal entity, a company or an LLP. This again is driven by several factors, including tax considerations, operational flexibility, compliance costs, and regulatory restrictions. That being said, in our experience, unless there are clear tax advantages for choosing an LLP structure over a private limited company, a private limited company offers more operational flexibility, particularly for foreign investment from a regulatory perspective. For instance, an LLP cannot take a loan from a non-resident partner. Similarly, the flexibility of doing a non-cash contribution in the form of IP or technology from a non-resident partner does not work in case of an LLP, owing to restrictions under exchange control law. These restrictions do not apply to a private limited company. Now, talking about a brownfield venture, in this format, the incoming JV partner acquires the shares of an existing company to reach the agreed shareholding pattern. Interestingly, from a regulatory or foreign exchange perspective, This model may trigger additional regulatory consent requirements if the proposed investment by the JV partner either results in the change in ownership or control at the JV entity level or triggers any government approval thresholds. For instance, a pharma manufacturing company will need prior approval from the Department of Pharmaceutical if the proposed foreign investment is more than 74%. Next slide, please. Talking about the pros and cons of this JV structure, the chief advantage is that an equity JV format offers universally recognized distinct legal entity to the JV with perpetual succession, the right to contract in the company's own name, and the right to sue and be sued. Since there's a clear identity ascribed to the JV, it's easier for the parties to have a well-defined, demarcated governance and management structure that separates the JV from the partners. As we discussed, JV partners enjoy the benefit of limited liability, shielded by the corporate veil, and the flexibility to raise external finance without exposing their own individual assets. Then there's improved liquidity and more exit options for the JV partners, as instead of selling individual assets or business verticals separately, parties can exit by selling the JV entity entirely. From our experience, this exit process is more streamlined and easier to execute from a valuation and closing perspective. Lastly, this structure adds greater stability to the business of the JV company, and the continuity of the JV company is not impacted in case of a change of control event at the JV company level. Coming to the cons, of course, the compliance and related costs are higher. There's a sunk cost attached to this model for incorporating and running the legal entity as a going concern. Then there's a higher risk of deadlock, a decision gridlock, particularly in case of 50-50 JV setup, that can lead to trapped investment if the JV partners fail to reconcile the competing strategies. Similarly, there's a potential risk for conflict of interest, as JV management can emerge as a de facto third partner with their own agenda. Lastly, as we discussed, termination or winding up is not easy and requires court approval. Next slide, please. Any discussion about equity JVs is incomplete without delving into governance issues or the standard management models. A key factor pertaining to governance of a JV entity is the degree of control that the JV partners can or want to exercise over the direction and management of the JV company. In case of a company, control can be exercised at two levels, the board and the shareholders level, and is effectively linked to the ownership pattern or the contractual rights that entitle the JV partners to affirmatively manage the day-to-day operations of the JV company. Talking about the common governance models, from an ownership standpoint, parties can either offer an arrangement where both the parties hold 50-50% of the share capital of the JVC and therefore exercise joint control over the management and affairs of the JV company, or there's an asymmetric ownership model, where one partner holds more than 50% of the share capital and thus exercises majority control over the JV company, typically subject to certain negotiated veto rights in favor of the minority JV partner. A 50-50 JV format typically envisages a management structure where the board and management is equally divided between the parties, and no single JV partner can unilaterally take any material decision regarding the JV entity. Given that neither side is effectively in control, none of the JV partners get the benefit of consolidation, and as we discussed, the risk of deadlock is relatively higher in this format. That being said, the imbalance of power that is inherent in any JV structure that is not equally split can have a way of creating its own problems, especially when there's a fallout between the partners and the minority partner refuses to cooperate, or there's a case of operation and mismanagement by the majority. In fact, given these issues, a 50-50 JV format is the most prevalent ownership structure across industries when compared to asymmetric JV structures. Interestingly, a quick fact, Water Street Partners, a US-based consulting firm, undertook a study in 2020 where they did a benchmarking of key demographic details of the world's 600 largest JVs formed since 1990. This study shows that 50-50 ventures have a longer average lifespan and in certain circumstances, even outperformed other JV structures. Quickly to add, there's one hybrid model that we've also seen in practice. This is where one party gets 51% majority ownership interest. And this is purely driven from a consolidation perspective. But for all other intents and purposes, especially the governance and management, the JV is structured as a 50-50 JV, and the agreement reflects this construct. Next slide, please. Given the long-term nature of the project, the costs involved and the time involved in negotiating the JV, setting up and running the separate legal entity, and the onerous winding up process, it becomes crucial to consider and address from a process and documentation perspective certain issues that are intrinsic to equity JVs. As Samir mentioned, to broad base this discussion and make it more engaging, we had circulated a question to all participants asking, in your view, what are the key legal and structuring issues underlying joint ventures? We got many insightful responses, so thank you for that. And the key ones that we wanted to highlight and discuss in the context of equity joint ventures are right there on the screen in front of you. Majority mentioned that having a suitable JV partner and cultural fit is must. I couldn't agree more. These issues are paramount for ensuring a successful JV. And from our experience, the key takeaway here is that effective diligence is key. Each partner should do a diligence on the credibility, reputation, sector-specific experience of the other JV partner and its founders and promoters. Just to add, it is also critical for the potential JV partners to have upfront alignment on the short-term and long-term objectives of the JV, including the funding obligation. Then the majority mentioned that robust governance is one of the key issues. I agree. For a successful JV, operational control should be balanced with good governance policies. A lack of good mechanism and ethical standards to internally regulate the governance of the JV company can have severe consequences, especially for foreign investors. Therefore, it is crucial for JV parties to adopt a variety of checks and balances, such as professional management, specialized committees consisting of representatives of the JV partners to take material decisions, and lastly, the need for independent personnel to be involved in operations and financial control. Then deadlock is another critical issue that needs a discussion. We all know it may not always be feasible to have consensus over all operational matters of the JV company, and therefore disputes are inevitable. JV partners should have a defined framework to resolve any deadlock between the parties. Here again, the ownership pattern of the JV company plays an important role in the structuring of a deadlock mechanism. And for instance, a put or a call option regime whereby one party gets to acquire the other subject party may be not workable in case of a 50-50 JV structure, especially where the business continuity of the JV entity is equally dependent on both the JV partners. From our experience in such a case, the only practical solution is that you do a 100% strategic sale, and in case that is not possible, liquidation is the only last choice here. Then exit options. It's equally important for the JV partners to discuss and chart out an exit path, with or without cause, and have a well-defined regime on the transfer of shares. This again is particularly critical for foreign investors, given the restrictions from an exchange control perspective. For instance, a minimum 1-year lock-in period applies before an investor can exit using a put or a call option, and the exit cannot be at an assured return given the pricing restrictions. Then moving on, IP protection. IP is undoubtedly one of the most fundamental aspects of any joint venture. Even if there's no technology or IP transfer, from our experience, at a bare minimum, a JV would entail co-branding or use of the partner's trademarks. Indian law offers protection for IP through registration with various IP agencies. So it's critical for a JV partner, especially a non-resident partner, to conduct due diligence to see if its IP is not exposed to Indian markets and should timely seek protection by registering its IP. Lastly, getting the JV agreement right. The significance of this issue cannot be overemphasized, as it is the mainstay for the other issues that we just discussed. From a documentation perspective, the terms relating to the incorporation, management, governance, operation, and capitalization of the JV entity, including the inter se rights and obligations of the JV partners, should be captured in a definitive binding agreement, often termed as a joint venture agreement or shareholders agreement. Further, from an ease of enforceability perspective, the contractual terms which are meant to bind the JV entity should be restated in the Articles of Association of the JV company. Interestingly, this issue and topic will be covered in further detail by my colleague in the next session of our M&A Academy, which will be on shareholders agreement. Next slide, please. So before we wrap up, to summarize the key takeaways that we just discussed, a JV is a highly fluid concept, and as Samir mentioned, there is a significant level of customization to each joint venture. While there are many variations that can be adopted from a commercial, regulatory, or tax perspective, common structures that we discussed were equity and contractual JVs. The key difference being that an equity structure entails formation of a separate legal entity, and the contractual JV is structured purely through a contract. That being said, in our experience, equity JVs are more commonly used, and a private limited company as opposed to an LLP is a more popular choice, especially where one of the parties is non-resident. Talking about equity JVs, we said that a 50-50 split is often the default setting when contributions are roughly equal and neither party is willing to seek control. But pulling off a successful JV requires navigating through several challenges which should be identified and addressed early on from a process and documentation perspective. Accordingly, appropriate and timely legal and transaction advice is a must. JV partners should proactively seek legal advice before implementing or finalizing any action that might have adverse legal implications. So that's the end of the presentation. Thank you for your time today. I hope that you found today's presentation helpful. Samir, over to you, and I look forward to answering any audience questions. Thank you.
Thank you very much, Sarthak, and we've been getting a lot of questions. That's what's been keeping me busy by the side. So maybe you want to grab yourselves and give me a moment. I'll just fish a few questions out for you. Okay, so we have right. Okay, so we're all set. So there's a very interesting offbeat question. What are the stamp duty implications on a JV agreement? So if you mentioned the JV agreement, somebody seems to be curious, what's the different stamp duty treatment for the various kinds of JV agreements?
Sure. So talking about the JV agreement, depending on the state where it's executed, mostly it's the standard, the residual entry that you'll find the stamping to be. Then and that amount is not significant. Rupee value not more than 1,000 rupees, dollar not more than $10 or $15. Now, the other aspects which are critical from a stamping perspective, what are the other elements to a joint venture? Is there an asset transfer? Then there needs to be a separate construct, say an asset purchase agreement or an asset transfer agreement, which will have its own stamp duty implications. Then is there a share purchase happening or issuance of equity shares at the time of investment? That again will entail its own stamp duty implications. Lastly, if there's an IP, contribution, technology contribution, that leg again will have its own stamp duty implication. So very interesting question, and this is something that from a practical perspective is a topic of discussion from a cost allocation perspective especially. So a good question there.
Excellent. So maybe let's take a leaf from that. In terms of what are the JV partners' contributions, there are at least 2-3 different questions around what if a JV partner wants to contribute in kind and not in cash, then what are the legal formalities to be observed?
So that's possible, non-cash contribution, and in fact it is common, particularly in cross-border joint ventures. From an Indian law perspective, it's doable. However, certain issues really become critical when a partner is doing non-cash contribution. Particularly valuation and the timing and sequencing of the investment is critical. Valuation issues become important, especially where the JV is a 50-50 JV and the other partner is doing a cash contribution. The reason being that, say, if someone is putting in $100 million as the investment, your technology or IP contribution needs to match that valuation in order to achieve a 50-50 ownership pattern. Again, when we said the timing issue is critical, that's more about sequencing the transaction. When you're doing an IP or a technology contribution, from a documentation perspective, you need the JV entity up and running to make the JV entity a party to the contribution agreement. So then, in this case, say the non-resident partner who's making the contribution cannot come in in the company at the incorporation stage. Unless you're doing a small cash investment, 50-50, you do it. But primarily, you'll come in the JV entity once it has been set up and the JV company is up and running. So see, these factors are very interesting and they need to be addressed early on, even before you put your head to a term sheet.
So maybe I'll flip to another question. So this is again on IP. You spoke a lot on IP as well. And let's say the JV partner doesn't want to contribute their asset to the JV. What are the other ways in which the IP can be protected as well as made available to the JV?
Sure. So even in our experience, what we've seen is that license of IP or technology is more common than an outright assignment. Frankly, nobody wants to dilute the ownership, right? So that's more common. And there are many ways you can structure this at different elements and times of the transaction. At the pre-contractual stage, say at that stage of the term sheet or getting into the contract, it's critical from a documentation perspective that you have your confidentiality agreements and non-disclosure agreements in place because it's sensitive, right? Technology is, as we said, IP and technologies are the key elements of doing the business activity in a JV. And then you need to have an upfront agreement on the licensing terms, or say if you're going in for an assignment, have an upfront alignment even before you're signing the contract, because that's the driving force. Now, once you've signed the agreement, the JV is up and running. The key factor for the contributing partner is to make sure that there is no reverse engineering or any other kind of misuse of the IP that you've licensed to the JV company. You achieve this through your contract plus through control over the operational level, the board. That's how you achieve that. Lastly, once the JV has terminated, assuming the IP is no longer being licensed, then there the key factor is to ensure that there's a clean exit. The JV is not being exploited, used, the technology, sorry, is not being exploited, used by the JV entity or the other JV partner.
Understood. So you spoke of board control and using the board as a mechanism to control the intellectual property. What's an ideal board size in a joint venture? Somebody's asked that question.
That's a good one. At least in our experience, I haven't seen an ideal size. It's purely driven from the transactional construct elements, and most importantly, what's the structure of your joint venture, right? If it's an equity format where you have a 50-50 setup, then in most cases the board will be equally split because neither one party wants to cede control to the other one. And here another interesting element is that nobody wants to risk consolidation. So you'll keep a 50-50 equally split board with a rider that, say, the chairman or no special member of the board has a second or a casting vote. In case of an asymmetric structure where one partner, of course, has majority, there the factor driving the board constitution is how many directors does the majority partner want, and typically what's the shareholding of the minority partner. What we've seen, what we push is that you have half, the minority will have half of, say, what the majority has. And in some cases where the minority participation is insignificant, then the majority may even just push for having an observer on the board as opposed to a director.
Understood. So just maybe moving on, there's a question on CCI approvals and whether whether merger control approval is required for a joint venture, particularly when you're doing the transaction itself?
The answer is yes. It's common for joint ventures to be assessed from the perspective of CCI approval. One exception to be mentioned here. So as we mentioned, there's a greenfield venture, there's a brownfield venture. Greenfield venture basis CCI decisions in the past. One can say that since there is no acquisition, there's no business activity at play, you're starting a new venture, right? So the CCI approval is not required. However, in case of a brownfield venture where you either contributing assets or you acquiring shares, and assuming the prescribed de minimis thresholds are met, then definitely the CCI approval notifiability is triggered and needs to be assessed.
Understood. Okay, just moving forward. I think there's a lot of questions on deadlock and how do you split control. So maybe I'll go step by step. There's one very interesting, very detailed question. So bear with me, I'll read this out verbatim. In a 50-50 JV, if one party is taking the operational control of JV, including specifically legal and other compliances and approvals, how common is it to have that partner or its KMPs controlling the operations to be identified as officer in default? And perhaps maybe you want to talk a little bit about the concept of officer in default as well. Also, does identifying the other partner as officer in default prove useful if something goes haywire? I think very elaborate question, but short point: party in operational control, should they wear the officer in default hat or should somebody else?
Very interesting question. But before I get into that, let's just take a step back. If you have a 50-50 setup, the recommendation has to be not one party should be seen as officer in default, because typically officer in default, the construct is that along with the company, you're seen as the executive piece running the key decisions, part of the daily affairs, right? So from the overall scheme of a 50-50 JV, that goes against the fabric of having a joint equal ownership. So in a practical example instance where you have a 50-50 and one partner has legal control over legal functions, it's common and it should be pushed by such partner to have an equally split owner concept and construct of officer in default for both the parties, since not one party will be taking single-handedly or unilaterally any material decision. So why risk the exposure of having your nominees or directors exposed to the construct of officer in default? So, if I think this is a very practical, specific question. So in this case, I think this needs more analysis from a legal perspective and from a structuring perspective. And the key takeaway here being that push for an equal split of the ownership and responsibilities along with the liability exposure here for the directors.
Great. Okay, let me turn to deadlock because the maximum questions are on deadlock. So I have questions on what's the best way to resolve a deadlock. I have questions on does expert determination work. I have questions on whether buy-sell works. One question says, is the ultimate sale of the JV assets, so not the shareholding, but the JV assets, if the dispute cannot be resolved, is that an incentive to agree or an incentive to dispute? So maybe go step by step on each of those items. You briefly spoke about deadlock before, but maybe just cover that again.
Sure. So deadlock is key, right? So it's understandable that we have multiple flowing questions on it. So great. Before we get into these specific questions, one element which is key to a deadlock mechanism, resolution mechanism, there are two fundamental elements there. The first one deals with the way to resolve the deadlock, right? And the other element is the exit, where the deadlock cannot be resolved, or certain related actions. But the first one, where you are trying to resolve the deadlock, and the deadlock can be both at a board or a shareholder level, and it typically is when there's no consensus over a material decision that impacts the business continuity. So the default position is that there's status quo. Parties don't do anything until it's resolved. How do you resolve it? There are two common practices here. One, if there's an operational dispute over a business decision, common practice is that you escalate to the senior management of both the parties, or there's a identified designated committee, you approach that committee, and they amicably try to resolve this issue. On the other hand, where the dispute or the issue is technical in nature, say the issue or the consensus can't be reached on the valuation, the pricing of the assets that you're buying, selling, then the common practice is to approach an expert for determination. Here you have a third-party identified expert, you make the case there, and the decision of the expert is final and binding on the parties. And until that decision is reached, as I mentioned, status quo is to be maintained. And all this needs to be clearly spelled out in the documentation and governed through the regime in the documentation, so that there's clarity for the parties. The next element that we discussed is the exit or the consequences where the deadlock cannot be resolved. Here, there are many variations, but the most common ones are the exit for one JV partner or say both. Just taking a detour and responding to that question that, is sale of an asset there also a common practice? I would not say a common practice, but there's one case where I've seen it, where the asset involved was not a crown jewel. It was just, a supporting asset. And there was a lot of dispute between the parties over that. So they decided the best way to resolve the dispute is to sell that asset. So that's where one case that we saw that. But coming to the exit, models here. In case of a deadlock, as I said, there are many variations, but there are some unique exit models in case of a deadlock. One is Russian roulette. Here, interestingly, what happens is that once there's deadlock, cannot be amicably resolved, then either one of the JV partners gives a notice to the other JV partner, asking that, exit, sell your equity stake, say 50% to me, at a specified price. This specified price may or may not be supported by a third-party valuation report. So there's this one option, or the other option is, which makes this more interesting, is that either you exit by selling the shares or buy me out at this, at this price. So here, interestingly, the offering shareholder is somewhere at the mercy of the receiving shareholder. Either you could be forced to buy the other shareholder out or be forced to exit. So extremely, interesting construct. The other one is Texas Shootout. Here, what happens is that both the parties submit a sealed bid to a third party, which could be, say, the auditor of the company, right? And here, what happens is that each party needs to offer to buy the shares of the other partner at a price. Both the bids are simultaneously opened on, say, the D day, and on that day, the party offering the highest price is then obligated to buy out the other partner. In both these, there are many other variations as well, but in both these common approaches, it's more critical for a foreign investor because there are implications from an exchange control law perspective, and this is a very important issue. There's, the foreign exchange law prescribes certain foreign pricing guidelines. You can't exit at a particular price, or you can't come in at a particular price. So the assessment and workability of these models need to be assessed in the backdrop of these pricing guidelines. And it's very critical that, you do that at the stage of the documentation and not when you are actually executing these options. The last, spending just 10 seconds more on this, the last common option that we've seen, are vanilla put and call options. And as we discuss, in cases where these are not possible because both the partners are required to run the JV operation, so it doesn't make sense for either one to get control 100%. So you either do a strategic sale 100% to a third party. If that's not possible, unfortunately, you need to liquidate the company.
So basically a whole host of possibilities, isn't it? And therefore you really need to apply yourselves. Yeah. Great. So just taking up put options and call options, because I know in some shape or form it's linked. So we have someone who's in the midst of a 60-40 JV, they're 60, the other guy is 40. And it seems that the 40% may potentially be acquired by an undesirable third party. And the question they're asking for is, in such a situation, how do you ensure that my 40% JV partner who will be acquired by an undesirable third party, how do I ensure that the undesirable third party doesn't influence the JV's decision making? I guess there are two ways to approach it. One is the specifics of the of the question. The other is generally how would you deal with this in a JV scenario to ensure there isn't somebody else who comes and sits on the table with you?
Very, very interesting question. And the joint venture is, not your classic acquisition where you do a diligence, find a target. A joint venture is more about getting into bed with the right partner, right? So in case of a joint venture, the best way to control who effectively your joint venture partner is in the future owned, or any restrictions around it, is to have a change of control restriction in your document. This is the most common approach generally to talk about this, that a JV partner should impose a restriction not just on the other JV partner for not transferring or transferring in a certain manner the shares of the JV entity, but even the shares and ownership of the JV partners themselves. Here, typically the model, how it works, say, assuming in your contract, in your 60-40 example, there are restrictions on the change of control, then typically how does that work out is that any change of control of a JV partner requires the consent of the other partner. And if you do not take that consent, then the partner gets the right, either it's in the form of a call option in most cases, to acquire the minority partner interest. Or to make it more aggressive, you could also have a put option where you force the minority partner to buy you out. So that's the contractual way to do this. However, assuming that you do not have the protection or benefit of this clause in your contract, then it's more about negotiation with your JV partner. Assuming that does not work, then unfortunately how it goes that the new owner or the new JV partner will step into the shoes of your existing JV partner, and then you will have construct that they are bound by the terms, because effectively the legal entity of the JV partner is not changing, right? So what rights your 40% JV partner has will continue to be available to the new owner, assuming there are certain restrictions around this, or assuming that the new partner wants to renegotiate certain aspects, in which case your 60% has the benefit of opening the can for further discussions.
Great. Okay, we spoke about IP, for example, where the IP is licensed to the joint venture. Those are things which we probably do at the formation of the joint venture. I guess on an ongoing basis, if let's say there's a need that is felt for one of the JV partners to provide either services or goods to the JV partner, and it lends to a related party transaction or a conflict of interest, how would you recommend that be dealt with?
So again, this is a very common issue that arises in most of the joint venture setup. Here, the key to protect both the partners and including both the partners against the management, right? Because there may be a professional management and they may have related parties, right? So is to make a related party transaction involving the company a affirmative vote matter, which requires approval of both the partners. And without that approval, the company cannot execute this transaction or not even get into a definitive binding agreement to do this, right? So from a related party perspective, assuming both partners are fine with it, it will need approval. Then there's a regulatory regime under the Indian company law around related party transactions. You have to make sure you comply with that. And then here, transfer pricing issues from a tax perspective and valuation becomes critical, because they're related parties, especially if the related parties are, one of the parties is a non-resident, then the transfer pricing rules apply. So it's very common, but you need to tread on this carefully and make sure as a JV partner you are protected, your value is protected, because both the management or the other JV partners should not get into related parties transactions to extract cash out of that company, because that's where your value gets impacted. So again, this is something that needs to be carefully looked by your advisors and not a generalist by a legal team consisting of both the tax guys and the corporate guys.
Great. Okay, I have a question which seems to cover a very novel concept. In JV agreements, we typically see good faith discussion and reasonable discussion clauses. What value do these clauses carry in actual enforcement?
So a very good question from a documentation perspective. Let me start by saying that these construct of reasonableness, best efforts basis, and are more common in other jurisdictions than in India. In India, they are unfortunately untested. So you'll see a lot of creativity, a lot of usage, permutations and combinations around these words from a documentation perspective. But talking about the enforceability, element here, where the clause says that on a reasonable efforts basis. So that's from an enforceability perspective, a party who's bound by this clause needs to show that, at a reasonable basis, as what any party would under similar circumstances do at a reasonable level, right? For instance, just to give a practical example here, if at a reasonable basis, you have to make sure that you get approval for, say, doing a particular activity. So on a reasonable basis, the obligation is that you make an application like any other person would. And then it's subject, you put your best foot forward, and then it's up to the regulatory authority, really, right? The best efforts basis obligation is more onerous than a reasonable, because here you have to establish that you went one step further. You undertook on a best proactive basis your action plan to make sure that obligation is completed. So using the same example, rather than just merely making the application, you have to factually show, you made rounds at the government, you tried to push this through, make a case for your approval to the right authorities using the mechanisms available in the law. So this is, it's nuanced. Again, as I said, it's untested, but conceptually, that's the key difference between these two constructs from a documentation perspective.
Great. I think we are on time. Maybe just non-compete obligations, I guess. Let that be the last question. And what sort of non-compete obligations do we see? Do we recommend those? Anything around that you'd like to talk about?
No, definitely. In case of a joint venture, especially, non-compete obligations are very common, and we recommend that the term, the scope is something that you need to, discuss, put your mind to, because the test of reasonableness still applies. But an interesting fact here is that Bombay High Court, in fact, a few years back in Novartis vaccines case, had indeed held that non-compete is effectively an integral part of a joint venture. And I remember reading this clearly that, it said there's an equitable duty on a joint venture partner to ensure that they do not compete with the joint venture business, even if there is no negative covenant in the contract. You can't take advantage of that and compete with the business. So yes, we highly recommend it, but the contours, the key elements of a non-compete needs to be thought through, because it varies, on a case-to-case basis, because what is reasonable is something that's fluid, right?
Okay, I think with that, Sarthak, thank you very much. Ladies and gentlemen, with that, we come to the end of the Q&A. And thank you for all your questions. Unfortunately, there are some questions we haven't been able to address. There are also some technical questions on valuation. Some of those we'll get back to you on separately. But thank you again for all of this participation. So before concluding, I would like to ask each of you to respond to a live audience poll. It should be on your screen now. We take this very seriously as a part of our continuous improvement. You will also separately receive a request for your feedback on the webinar. The feedback form takes less than a minute to complete, and it provides us with invaluable insight on future activities. So thank you to everyone who participated in the poll, and perhaps we'll just take a minute to summarize the key takeaways of the webinar. At least to me, a joint venture is and can be exactly what you want it to be, a result of the parties' mutual business needs and priorities. And therefore, as always, it is important to think through a clear set of priorities and educate your deal team on the same, so that they always have their eye on the ball. And given JVs are all about life going forward, there is a certain level of unpredictability that one needs to underwrite. If there is a change, But to the extent that there isn't a change, it is critical to have good advisors who can intelligently gaze into the crystal ball and identify future risks upfront for you and help you factor those into your joint venture structure. Finally, I would like to thank Sarthak for such a pragmatic and experience-enriched presentation, and also you, our audience, for your attention and overwhelming participation. We hope you found the webinar interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you. And please do not hesitate to contact us regarding any matters arising from this webinar. Our contact information is on the contact slide here. Thank you once again for your attendance, and we look forward to being of service again in future webinars.